Hi, this is Scott Pierce. Today's seminar covers criminal law and procedure. I think you'll agree when you're done that this is an interesting and useful subject, and that now we're into some material that's somewhat easier than what we've started with. It seems to me that it's useful to break down the different subjects in our own minds for organization purposes. Torts, contracts, property, and remedies really all fit together. To my way of thinking, they're all part of one broad subject, civil liability. All of these subjects are tested together. We'll see a little bit more of that when we get to civil procedure. But to my way of thinking, criminal law and procedure, constitutional law, and to some extent evidence all fit together in another little category. And we'll see during this seminar, and also during our seminars on constitutional law and evidence, just how inextricably tied together these three subjects really are. Of course, the bar examiners can test all of the subjects simultaneously, and we'll see a number of instances in which several subjects are on the table at the same time. Take a look with me at the criminal law and procedure approach, and let's begin with the minimalist approach. This gives us an opportunity to get the big picture together before we settle into the details and then get into practice. Notice that I observe up front that criminal procedure is more important and more complicated than criminal law. Criminal procedure is our first step into constitutional law. And as I explained right at the beginning of our minimalist approach, criminal procedure is testing us on our knowledge of the Fourth, Fifth, Sixth, and Eighth Amendments. The Fourth Amendment and unreasonable search and seizure. The Fifth Amendment, self-incrimination and double jeopardy. The Sixth Amendment, the right to counsel and the right to confront, and the right to a jury trial. And then the Eighth Amendment involves the death penalty and cruel and unusual punishment. It's also worth noting up front that much of criminal procedure is connected to the law of evidence because of the exclusionary rule. We'll get a lot more into that in this seminar and in evidence. Okay, that's it for criminal procedure. The Fourth, Fifth, Sixth, and Eighth Amendments. That's basically what's going on. Criminal law is very similar, as far as the exam is concerned, to the law of torts. All of the different crimes have prima facie case elements, and our job is to know these elements, to split our analysis up into separately headed sections about these elements, and then, narrowly and specifically, connect the facts from the pattern into elements of our legal analysis. So, in our little minimalist approach here, you'll see that I break criminal law down into just a couple of categories, the crimes and the defenses. As I consider the crimes, I think about crimes against people and crimes against property. This is very similar to the way that we think about torts. And I also consider the inchoate or preliminary offenses, attempt, conspiracy, and solicitation. And all of these issues have been tested in some depth in the not-too-distant past by the California Committee of Bar Examiners and the National Conference of Bar Examiners. When we get to defenses, we consider self-defense and insanity, both very commonly tested. Okay? That's the big picture of criminal law and procedure, or, as I expressed it, criminal procedure and criminal law. So now let's take a look at the more elaborate approach and consider a somewhat more in-depth way to think about this material. I note that criminal procedure falls into two broad categories, those that are directly connected to evidence because of the exclusionary rule, and those that aren't connected to evidence. The Fourth Amendment is perhaps the most commonly tested set of issues on criminal procedure essays on the bar exam. Notice that I break this issue down into 5 pieces: standing, consent, exigent circumstances, the automobile exception, and search pursuant to a lawful arrest. Now, the good news is all of these issues are tested in much greater depth every single time on the multi-state bar examination. The best way to learn this law is by doing a lot of multi-state questions. The best way to apply this knowledge is by doing practice essay questions. but they're testing the same basic issues, and we'll see that their use of language is quite similar as well. The Fifth Amendment deals with Miranda and coerced confessions, and it's also quite commonly tested. We'll see that these issues all are going to come up again when we consider evidence. So, a little flash into our future. Whenever we're dealing with an evidence essay arising out of a criminal case, be aware of criminal procedure issues. They almost always will be present. And then, finally, the Sixth Amendment, the right to counsel and the right to confront. These issues also will come up in evidence more than once, but we'll look at them first here in criminal procedure. Then, the issues in Crim Pro that don't relate to the exclusionary rule have more to do with the actual litigation itself. The right to various pretrial interests such as bail, preliminary hearings, and grand juries, the criminal procedure aspects involved in a reasonable trial, including, for example, a judge who doesn't get paid based on the number of convictions, and the requirements of competent defense counsel and ethical prosecution, and reasonable presumptions and jury instructions. Then, finally, there are post-trial rights tested in criminal procedure, and those relate to double jeopardy and the death penalty. Next, we consider criminal law in depth. Here, I break it down a lot more. But once again, if you've got a well-organized way to remember the law of crimes, go ahead and stick with your approach. There's no reason to reinvent the wheel. But if this law's been a little clumsy for you over the years, you'll find that my organizing principle is consistent with what I've presented before, and also well within the mainstream of how legal scholarship views these issues all the way across the United States. So remember, we're breaking crimes down into crimes against people, crimes against property. And that ought to be familiar to you because that's the same way we organized the analogous material in the civil law of torts. With regard to crimes against people, homicide is by far the most commonly tested, and it's probably also the most common theme for evidence questions involving criminal law and procedure. All of the other various sins of criminal law are tested in the law of crimes against people, including rape, robbery, mayhem, etc. I won't read the laundry list to you here, but you need to realize that there are a number of crimes against people. It's a finite list, and you want to know these crimes, and you want to know their elements. But notice, I am not advising you to memorize elaborate boilerplate definitions to recite in your answers. As you'll see, criminal law and procedure questions often tend to be racehorse questions, and whenever we're dealing with an issue-packed essay, the last thing we have time to do is recite a lot of boilerplate law. We've got to strip the definitions to the bare minimum. We need to use the elements of the different definitions as organizing principles, and here, as we've already seen in other subjects, where we have a number of facts relating to one issue, we can use the facts themselves as an organizing principle. Next, I list the crimes against property. Burglary and arson are perhaps the most commonly tested, but we also see the various theft crimes, which I take the time to break down into various relatively small categories. Finally, we consider the inchoate offenses: solicitation, conspiracy, and attempt. These, obviously, are tested on every multi-state bar exam, and they've been neglected in California for some time, until recently. We'll have a look at a couple of recent California bar exam essay questions dealing with inchoate offenses. It's really quite an interesting topic. Next, we consider defenses, and here again I reveal my own bias. I've been a defense lawyer in criminal court as well as in civil court. I guess these things can be traced back to childhood. I always was a better chess player, playing with the black pieces. And during my rather extensive involvement in organized sports, I always emphasized defense. Some of us are just born to be aggressive, and others work out our aggressions by being on the defense. So the defense in criminal law and procedure is relatively straightforward, and the law involved is really finite. Obviously, the most common defense is a claim of innocence. I didn't do it. And then there are other somewhat more technical claims, which politicians like to decry as guilty going free on a technicality. Well, let's look at some of those technicalities. The insanity defenses, again, always are tested on the multi-state. They have been tested a number of times over the years on the California essays and on the multi-state essay exam. We'll have a look at a couple of them. I list those defenses here. The distinctions between them are fairly thin, but this is some law that you need to learn, and you need to memorize it if you don't already know it. Intoxication is another defense, either voluntary or involuntary intoxication. Again, this is common fodder for the multi-state, and it's also turned up on a California essay or two in the not-too-distant past. Next, infancy, and then justification, where the defendant admits to the act, but says that he or she had a right to engage in that act. Self-defense, defense of others, crime prevention, apprehension of a fleeing felon. Again, all of these are tested in a lot of detail on the multi-state. We need to be prepared for them here on the essays too. Next, we consider duress, mistake, entrapment, and consent. All of these are possible defenses. So even though we are out of civil law, at least for the time being, we need to consider the same basic analytical approach. In a criminal prosecution, the plaintiff is the prosecutor. The prosecutor represents the people, and the prosecution has to establish each element of each theory of liability in order for a defendant to be convicted. And remember, the standard of proof is different and higher. A prosecutor has to achieve proof beyond a reasonable doubt, whereas in civil court, the burdens are substantially lower for the plaintiff. So the defense does not have to prove innocence. The defense has to raise a reasonable doubt. But the basic approach to essay writing remains the same. The plaintiff has to make his or her case. The defense gets a turn, and then we establish the result. That's the basic framework. The theories of liability and the defenses break down into elements. Our job is to spot the issues, break them down into elements, and then apply the facts. So, all of the skills we've been working on with regard to outlining and analysis will be continued and extended in this seminar as well.